Ross Armstrong. I'm the Executive Director of the Nevada Commission on Ethics, and we're going to do a presentation now regarding the ethics law and how it applies to your boards and commissions. So we're going to talk a little bit about why ethics matter, what we do as the Nevada Commission on Ethics, how we can assist you, who is covered under the Nevada ethics law. We'll talk about key areas of the law. We'll focus a little bit more on disclosure abstention today than we do in our normal training because of the nature of our boards and commissions. That seems to be a regular question, and then we'll talk about some resources and contacts. So why do we have an ethics law in the state of Nevada? The answer is Richard Nixon. And the Watergate scandal really triggered states and the federal government to enact ethics laws. And Nevada was one of those. So we enacted our first ethics law in 1975. It has changed a bit over time, mostly with the arc towards enhanced enforcement when there's violations. But if you think about it, the state went for over 100 years without any ethics law in the books, and the only recourse was the criminal law and then people voting out corrupt politicians. So the Nevada ethics law was established to set rules, primarily focused on what came out of Watergate, which was an elected official using their public resources to benefit their political campaign. In the legislative declaration of the Nevada ethics law, it says a public office is a public trust and shall be held for the sole benefit of the people. And we'll be going over a lot of technical rules today, but if you keep that in mind, that a public office is a public trust and shall be held for the sole benefit of the people, you'll be able to identify an ethics issue ahead of time, right? It's the sole benefit of the people, not for the sole benefit of the people in government or friends and family of people in government, but for the sole benefit of the people. Why do ethics matter on a bigger scale? If your board or agency gets mired in ethics issues, it dissolves trust in your board or commission and doing the good work that you do on a regular basis, and it undermines the hard work that your staff and you as a board member do every day on behalf of the people in the state of Nevada. A little bit about who the Nevada Commission on Ethics is. We're an 8-member commission. 4 are appointed by the Legislative Commission, 4 are appointed by the governor. At any given time, we cannot have more than 4 members from the same political party. 2 of those 8 must be licensed Nevada attorneys, and 4 must have previous public service. Because we're examining the conduct of public officials, we want folks who have experience with government work. In addition, our commissioners are prohibited from holding any other public office, and they're prohibited also from being actively involved in the work of any political party or campaign. What are the major functions of our commission? And I'll talk about this in terms of relations to your boards and commissions. So we have 3 major functions, and they fall on a spectrum between prevention and enforcement. The first thing we do is we do education and outreach about Nevada's ethics law. I'd much rather be here helping to teach you and train you rather than, at your board or commission to to interrogate all your staff after something potentially has occurred. So if you would like training for your board or commission, you can always reach out. We're happy to provide that on as needed basis. We also have online on-demand training available at ethics.nv.gov. Our second function is that we provide advisory opinions. So every public officer or employee can request from the commission an advisory opinion, as long as it's 1, about the ethics law, and 2, about your conduct. Not your fellow board members' conduct, but your own conduct. And so the way that happens, it's a confidential process. You submit a request for the advisory opinion. There's sort of we engage with you and figure out all the facts we need. We determine what the best advice is given the law. The commission votes to grant that opinion, and then you have an opinion that tells you what to do. This may be a good idea if you're on a board or commission and you have maybe a recurring conflict of interest you think may come up. Perhaps you're on a board or commission and your employer is regulated by that board and you want to know what you need to do in terms of disclosure and abstention on voting issues to not run afoul of the ethics law. And then the last thing that we do is we receive and process complaints alleging violations of the ethics law. I think last fiscal year we had somewhere around 130, 140 complaints that we processed during the year of folks who believe there were violations of the ethics law and asked us to take a look at that. So who exactly falls under the jurisdiction of the Ethics Commission and what types of conduct does? I think in our gut we know we can see something, or we can better define something that's unethical or it seems shady, but it can be harder to determine what is the actual the ethics requirements for our public officers and officials. And it has to be something that is found, a rule found in our ethics law, which is NRS 281A. So this graphic helps you figure out what is and what isn't. I'll point out two things to start. One, we only have jurisdiction over public officers and employees. You'll hear that term a bunch. A public officer is a position that is established in law and executes a government function. That's kind of the basic definition of it. So if you're on a board or commission and you have licensing or regulatory authority, your position is likely established in NRS. If you're a local board and your board is established by a county code or the city charter, you're also going to be a public officer. And then public employees are anybody who gets paid compensation to work for a public officer. So if you have some sort of intern at your board or commission, they're not paid, they would fall outside of the scope of our jurisdiction. But if they're getting paid compensation, they're going to be a public employee. We don't have jurisdiction over whole agencies. Sometimes people call us and say, hey, this entire board is violating the ethics law. Can you please find that they're unethical? We don't do that. We only take jurisdiction over individuals. We also have a 2-year statute of limitations. As you can see in this infographic, there's a lot of things we do not have specific jurisdiction over based on our law. We don't have any jurisdiction over employee grievances, harassment, open meeting law concerns, discrimination. Judges fall outside the scope of the definition of public officers and employees. We have no jurisdiction over public records disputes or anything that could be filed with the EEOC or NERC. And there's no rule in the ethics law that a public officer can't do harm to somebody else or be incompetent. Sometimes we see those folks think their public officer is incompetent and they want us to do something. It has to be one of these 3 topics down below. So there's improper benefits rules, cooling off periods, and then disclosure abstention. As I said, we're going to go through those details here in a second. Before we dive into the specific rules, I want to talk about this definition in the law, which is a commitment in a private capacity. When we see people before the Ethics Commission and they're in trouble, there's basically 2 types. One type basically doesn't think that the rule should apply to them, and the other type is someone who's trying to do the right thing and maybe they've stumbled into an ethics situation. And where they often stumble is that they're not thinking about the relationships that trigger a conflict of interest. So under the ethics law, these are the 6 types of relationships that create a commitment in a private capacity. And that term is seen 14 or 15 times throughout the ethics law. And these are folks, so the ethics law says you have a conflict of interest with these individuals. Just having a conflict of interest is not an ethics law issue. The issue comes when one of these relationships comes into collision with your public duties and you take some sort of action contrary to the ethics law. So let's go over these 6 relationships. The first one is a spouse or domestic partner. So if you have a spouse or a domestic partner, they are on your list. A member of your household, so if you have somebody living with you who is also related to you, then it can be a member of your household. You're going to have a commitment in a private capacity to them. The next term is fun because it's super technical and legalistic. Anyone within the 3rd degree of consanguinity or affinity. So we'll talk about that real quick. Consanguinity is just a fancy legal term for how closely related you are to someone. So you're at the 0 degree of consanguinity, your parents and your children are at the 1st, and it goes out from there. And so the ethics law says if it's within that 3rd degree or closer, you have a conflict of interest with that person. So on this particular chart, any relationships to the left of the dotted line are within that 3rd degree of consanguinity. Any of the relationships to the right of that dotted line are outside that 3rd degree of consanguinity. The ethics law applies the definition of commitment in a private capacity, not only to those related by blood, but by marriage. So all of your in-laws that would be on the left side of the dotted line also count within that 3rd degree of consanguinity or affinity. The next relationship is employer. If you're serving on a board or commission, you are likely employed some other way as a full-time or half-time job. So if you are on a board and you work for a coffee shop, then you have a commitment in a private capacity to that coffee shop. And if that coffee shop's interests come into collision with your public duties, you're going to need to think about the ethics law. If you have substantial and continuing business relationships, those relationships also trigger this commitment in a private capacity. Let's say instead of working for the coffee shop, you own the coffee shop. Well, you're going to have substantial and continuing business relationships with the company that provides you beans and other vendors of your agency. Maybe you have a corporate landlord. Those types of relationships are also going to create a conflict of interest. And then just for fun, there's this, or to keep attorneys employed, there's this definition called substantially similar, which says if it's a substantially similar relationship to those other 5, it also counts. And that can be somewhat hard to define, but I'll give you some examples. Let's talk about ex-spouses. So under the law, under the first part of this definition, only spouses or domestic partners have your commitment in private capacity. But we've had some folks reach out to us in advisory opinions and ask if an ex-spouse is substantially similar. And the commission has answered both ways. So in one case, we had ex-spouses where there was no child support, no alimony. They lived in different states. They clearly didn't like each other or talk to each other. All the children were grown. They really had no connection or relationship that was similar to a spouse. In another case, though, we had ex-spouses who continued to live together, share expenses. There was a child in the home. They saw each other every day. We said that relationship is substantially similar and qualifies as a commitment in a private capacity. Some additional examples of substantially similar, the commission has regularly held that if you serve on the board of a nonprofit, that is substantially similar to continuing business relationships, even though it's not quite, because there's not usually an exchange of money in that case. But because you have a fiduciary duty to that nonprofit through your board service, it is substantially similar, and therefore you need to be thinking about the ethics law as it comes before you. And then in addition to that, there have been some cases where it's determined that a friendship is substantially similar to someone within that 3rd degree of consanguinity or affinity. So if we go back here, remember the ethics law doesn't care if you like your family. If they're to the left of that dotted line, you have a conflict of interest. And you can probably think of friends that you have more interaction with, that you're closer to. Maybe you have daily interaction, go on vacations, exchange gifts, and they are substantially similar to those relationships on the left-hand side of the dotted line. I was in a training yesterday, and one of the ones we talked about was cousins, technically outside of the 3rd degree of consanguinity, but you may have cousins that are you feel closer to than some other folks on the left of the dotted line. And if you have that type of relationship where you're regularly communicating, you have gifts, you share finances, you're traveling together, that may result in a finding that that relationship is substantially similar. We're going to dive into the 3 main areas of the ethics law. Now, these buckets are proportional in size into the number of rules, but because we are at a boards and commissions training, like I said, I'm going to focus a little bit more on disclosure and abstention than we would if we were, say, training staff that are, public employees working full-time. But the 3 main topics are improper benefits, disclosure and abstention, and cooling off. The improper benefit bucket has this basic formula. You cannot use your government position to create a benefit for yourself, a gift or a loan for either yourself or someone that's on that magical list of relationships, that commitment in a private capacity. So there's lots of little variations on that rule, but really that improper benefits bucket of the ethics law is about not using your government position to create that benefit for yourself or someone on your list of relationships. Let's talk first about gifts because it's been a hot topic and people often ask about gifts. The standard under the ethics law is that as a public officer, you cannot receive a gift, service, favor, or engagement that tends to improperly to influence a reasonable person to depart from the faithful and impartial discharge of your duties. So that's super clear, right? So let me give you some examples and we'll talk about what the Ethics Commission looks at. In Nevada, unlike some other states and jurisdictions, we don't have a flat gift limit. There's no like $50 or more. There's a gift limit. Your local agency might. You can certainly adopt policies that help with clarity for your boards and commissions. But the standard under the ethics law is this: hey, would this gift tend to improperly influence a reasonable person to depart from what they're supposed to do? And so what the Ethics Commission looks at is really sometimes the value of the gift, and the nexus between the gifter and the giftee's decision-making abilities. So if you think about, let's say you have a friend and you go to lunch 4 or 5 times a year. Sometimes you buy, sometimes she buys. When she buys, that's a gift. But is that going to tend to improperly influence a reasonable person to depart from the faithful and impartial discharge of their duties? No. I would say probably not. Every ethics case is really fact-dependent. And you can distinguish it from a situation where, let's say that your board is considering an RFP, maybe for a new computer system or for, maybe you're looking at a new office. And so one of the applicants takes you out to dinner a week before you're going to vote, and they fly you to New York for the dinner and they shower you with gifts. Clearly, that's going to tend to improperly influence a reasonable person to depart from the discharge of their duties. It doesn't matter if you are the most ethical and unpersuadable person in the history of the world. The question is not if you were departed from the impartial discharge of your duties, but a reasonable person would be. So some case examples. We have Enrique Lopez. Lopez was a director at a state agency and received from a current vendor a coach purse, lunches. There was some luggage loans that occurred, and the commission said, look, this is a vendor that is currently engaged with their agency. This person is in a position to determine if this vendor remains a vendor or gets renewed, and so that was a violation of the ethics law to receive the coach purse and the lunches, and resulted in a $1,000 fine. In Ray McClinton. McClinton is the head of the Governor's Office of Energy, and he received 2 Vegas Golden Knights tickets and access to an exclusive partner party. The Golden Knights were hoping to get a sponsorship from the state, from the Office of Energy, and so because the value of those tickets was high, and there was an official ask to get state money at the time, the commission agreed that that was a violation of the ethics law and fined him $1,000, which was the value of the 2 tickets plus an additional fine to help deter future conduct. Switching to 2 advisory opinions, because I talked about how we have complaint cases and we have advisory opinions when people when people proactively ask us. So the city of Reno, Century Theaters, movie theater company, approached the city of Reno and said, hey, we'd like to give folks annual passes, your city council folks annual passes as a thank you for their public service. And the city of Reno said, hey, before we accept this gift, let's go ask the Ethics Commission. And so they asked the Ethics Commission, and we did some research and determined that the value of the gift, although it's unlikely that somebody would go to the movie theaters every single day, if they did, it was a gift in the thousands of dollars. And at the time, the theater company was trying to get approval to build a theater in downtown Reno. And so the Ethics Commission said, do not take that gift. It would be a violation of 400 subsection 1. Another great advisory opinion was in Ray Brown. A agency director asked if they could go to a conference. The conference had a government rate for the tickets that was reduced. It was a lower rate than for corporate folks who were going to the conference. And so the director said, hey, is it okay to take this discounted ticket, or does that constitute an unlawful gift? And the commission said, here's this conference attendance is closely related to your public duties. If this is not just a special gift for you as the director in Nevada, this is applicable to all government agencies, and so therefore the discounted ticket was not an unlawful gift. We'll talk about the use of resources a little bit. Unwarranted privileges, preferences, exemptions, and advantages. 402, we see this claim a lot. The key word here is unwarranted. So the law defines unwarranted as without merit. What you want to be thinking about is is there a specific government purpose for that benefit? So if you have a board meeting and you decide you're going to have your board meeting in Tonopah, and the state has travel guidance that says, hey, if you're traveling for state business, you can have your hotel and your transportation and your per diem food paid for by the state. Somebody on the outside may say, hey, you got a vacation to Tonopah paid for by the state, but it's not unwarranted because you were doing the work of the people while you were there. As long as you comply with all the rules in the state administrative manual and the GSA rates, those types of things, it's not going to be unwarranted. I'll give you an example from another state. In the state of Oregon, liquor is highly regulated. There's special state liquor stores, and members of the Liquor Control Board were holding back rare and expensive whiskeys for themselves. So they would make sure that those whiskeys didn't hit the shelves for everyone to purchase. They would have them held off in a storeroom. That's an example of an unwarranted privilege. They weren't stealing the whiskey, right? They were just saying, hey, this particular one set aside, I'm going to have access to it that the general public wouldn't. So if you're in a regulatory board, think about if somebody's applying for a license or there's some sort of waiting list for services, right? If you use your position and it's someone within your magical list of relationships to either, provide them a license when they shouldn't or bump them up a line in terms of review or services, that would be an example of unwarranted privilege. No salary compensation from a private source for performance of your public duties. This is our version of don't take a bribe. So don't take money from someone. Maybe, you are doing a disciplinary hearing and the person at issue wants to pay you to vote a certain way. That would be an example of 281A 400 subsection 4. Again, it would also be a crime, and so there can be ethics violations that are crimes. You cannot benefit yourself or others using the influence over a subordinate. So if you're a board member, you can't have your executive director off doing all sorts of things to benefit your personal or private interests. And then there's a restriction on honorarium for speaking. And I like to put this in here because this is a great one to ask your DAG. If you're asked to speak at something, let's say the local chamber of commerce wants to hear about your board. They say, hey, come to our lunch. We'll give you lunch. And you can speak. It will be great. There are rules within the law that say, yeah, you can eat the chicken lunch. If there's a necessary cost to get you to the place where you're speaking, you're fine. It's the actual here's $800 for showing up to our lunch in your position as the head of a particular board that would get you in trouble. So know that there's a rule about that. If you are asked to attend something and are either provided compensation in one way or another, you want to be asking your DAG about the limits about what can be provided or not. Another improper benefit can be contracting. So you need to be aware that you cannot negotiate a contract with yourself or others on your magical list of relationships with your current agency, right? We don't want public officials negotiating contracts that benefit themselves and their agency because you're going to deviate from benefiting the sole benefit of the people. You're going to get a benefit on both sides. And so if you are a vendor or your family is a vendor that your agency is looking at, you want to check with your DAG to see what you need to do to remove yourself from that particular situation. In addition, as a public officer or employee, you're prohibited from contracting with any other government agency. Under 281A 430, there are lots of exceptions. So you want to see if the contract you're looking at may be exempt from that rule. And there's a process through our advisory opinion process where you can ask for relief. You can say, I know that this contract, like if you're a member of Board A and you in your private capacity want to go be a contractor for Board B, you can, one, check to see if the contract falls within the exceptions of the law, and if not, you can ask us for permission to enter into that contract. You want to do that, of course, before you enter that contract because we don't grant relief when somebody has already violated the ethics law. Some case examples. In Ray Juden is a case where a city manager negotiated a post-employment contract with his agency while he was still employed. That resulted in a non-willful violation. So he was city manager, negotiated, hey, I'm going to be leaving the city, but we're going to have a contract with me afterwards. Because he was city manager at the time when he negotiated that contract, that was a violation. In Ray Augustine Kathy Augustine was our state controller, and she was running a campaign out of the basement of the Capitol building here in Carson City. And she used staff for campaign work, like stuffing fundraising envelopes and using all sorts of equipment to benefit her campaign. That ended up being a violation. For our constitutional officers, if they receive one willful violation of the ethics law, it requires referral to the legislature for impeachment. So that is what happened in the Kathy Augustine case. For other public officers, so for those of you that are board members or commission members, if you receive 3 willful violations, not necessarily 3 cases, but 3 willful violations in any given case, then the Nevada Commission on Ethics is required to file a legal case in your local county to have you removed from office. An example, In Ray Allen was a county commissioner. There was some litigation, and she influenced her county manager to issue a settlement payments to her ex-spouse. And then In Ray Cooper, and I think this was on Tammy's slide, was, as for one of the audit issues, was the massage board executive director used her position to pay herself extra paychecks. I think there were like a dozen extra paychecks over an 18-month period, and so that was a violation of the ethics law. One of the ones that we see more with staff than necessarily with board and commission members is 400 subsection 7. You are prohibited from using government time, property, equipment, or other facility to benefit a significant personal or pecuniary interest. So if you're issued, let's say, a board iPad or laptop, and you're using it to run your private business, that's going to be a violation of 400 subsection 7. Tammy and the audit team, they spoke about, knowing some internal controls and policies of your board. So as board members, I would encourage you to know what your policies are in relation to the use of equipment, because there may be some use of equipment that you would want individuals to be able to use in limited ways that may benefit their personal interests. So if you have a policy or there's an emergency, there can be an exemption to this particular part of the ethics law, so long as the use doesn't interfere with the performance of their duties, the cost is nominal, and it does not create the appearance of impropriety. So the example I like to give is, say you are, let's say that your board has vehicles, right? And one of your staff members swings by a convenience store, gets like a Slurpee or a drink or something. That's a pretty nominal use. Is that allowed under your policy, right? You want to have clear policies about that type of minimal use may be allowed, but you cannot like load everybody up into the board's van and drive your family to Disneyland type of thing. So be thinking about that. What types of policies do you have in place in terms of use of equipment? It can help prevent an audit finding and then also violations for your staff members. Some case examples in terms of use of time and equipment. In Ray Cochran was a fire chief in Reno. He used his uniform and some fire trucks in a video endorsing a senator's re-election campaign. That was a violation. In Ray Hall was the Mineral County Commissioner. She used the county credit card to purchase food and booze for her business. She paid it back, but she, still used the equipment. And then in Ray Prudent, he was a county treasurer who was using county computer and time to take college courses instead of doing his job as treasurer. That again resulted in a violation. Go ahead and take a second to read this quote. We're going to shift now into the disclosure and abstention part of the ethics law, which I think there may be the most questions about for this particular group. The improper benefits bucket is about securing benefits or some sort of advantage for yourself or someone on your magical list of relationships. The disclosure and abstention bucket is just about transparency with your conflicts of interest. You don't lose your humanity just because you're a public officer. You don't have to cut off all relationships and ties and interests, but when they come into collision with your public life, that's when you need to be thinking about disclosure and abstention. We'll walk through both. I will say that although disclosure and abstention are in the same bucket, there's a very different analysis. And we see a lot of folks, especially on boards and commissions or city councils, a county commission, struggle with the idea that there are two different standards. So for each of these, you want to be thinking about, first, do you need to disclose? And then second, do you have to abstain, right? Because you're going to disclose more often than you're required to abstain under the ethics law. The ethics law says, look, before approving, voting, or acting on a matter, if you've received a gift or a loan, you have some sort of significant pecuniary interest, that's just our fancy ethics term for money, or you can be reasonably affected by a commitment in a private capacity, you need to make a disclosure. And so as a quick reminder, right, there's our 6 relationships that create the commitment in a private capacity. When folks stumble into a disclosure issue, it's usually because they're not thinking about this list of relationships when items are before them. I will also say be very cautious about consent agendas because folks tend to be like, oh yeah, consent agenda, that's good. If you have a conflict of interest within that consent agenda, you need to be disclosing prior to voting on that consent agenda. So what is a disclosure? A disclosure is just a transparent and public declaration like, hey, I have an interest in this particular matter. If you look on the left, I think you'd see what we'd all call an insufficient peanut butter and jelly sandwich. There's some missing details there. The same thing can happen with a disclosure. So your disclosure has to be sufficient to inform the public of the potential effect of the action or your abstention upon the person or the interest, and it has to be made at the time the matter is considered. So for boards and commissions purposes, you are in a board meeting, there's an agenda item, there is somebody on your magical list of relationships, or you have some sort of interest, you need to state on the record, I need to make a disclosure, I have this relationship with so-and-so, this matter could affect them because they are a licensed, let's say, chiropractor, and we're going to raise the fees on chiropractors, and so I need to disclose that I have somebody who's in my magical list relationships that will be affected by this matter. You have to make it at the time you're considering it. You can't just say, 3 months later, oh, I had a conflict of interest 3 months ago, just so you know. And it also needs to be in enough detail so that the public can judge your action thereafter. Abstention, on the other hand, is when you as a board member or a commission member don't vote. So you're actually sitting out the decision because the impact of the matter is so direct. And so the ethics law says you shall not vote upon or even advocate for. So you can't be advocating for the matter and then at the end say, oh, I'm going to abstain. If the independence of judgment of a reasonable person is affected by, again, it's a similar list, your own pecuniary interests. Let's say you are regulated by your board and you're increasing or decreasing licensing fees. You clearly have a pecuniary interest in that matter. You have a commitment in a private capacity. So again, your magical list relationships, or you've received a gift or a loan from someone that could be affected by that vote. We can't have an abstention rule that is so strict that everybody has to abstain all the time. And so the ethics law presumes that public officers act in the benefit of the people, so long as you make the disclosure. So that's the key. You have to make the disclosure. If you don't make the disclosure, you don't get the presumption, what I call the presumption of participation. As long as you make that disclosure, the ethics law says abstention is only required in clear cases where the public officer's situation is materially affected. So if it's some remote interest, some kind of speculation interest, it's not very clear, you should probably disclose. It's always good to err on the side of disclosure, but as long as you make that disclosure, you don't necessarily need to abstain if you're not going to have some sort of clear case where you're materially affected. It's also, and this one applies probably most to our boards and commissions here today, is that it's presumed permissible if there's no benefit or detriment to you than anyone else affected by the matter. So think about, we're going to raise the fees to be a chiropractor. You're a chiropractor, you're going to have to pay the fees you have to disclose because you're going to have to pay that extra fee, but because the fees are going up for everybody, you can still participate. So you'd make your disclosure on the record and then say, the ethics law allows me to participate because I will be affected no greater or less than by anybody else who may be affected by this vote. It's important to note that this is a case-by-case basis and it's an item-by-item basis, so you should really be working with your agency attorney to determine what you need to do. And again, err on the side of disclosing and being detailed in that disclosure, and then your agency attorney can help you with abstention. What I will say is when I go train agency attorneys, they indicate that sometimes, like this question comes 30 seconds before a vote, which doesn't give them a fair chance to do some research or call for help. So as soon as you see an agenda item where you might have a conflict of interest, that's when you should reach out to your agency attorney. I'll note one really great case. So in re public officer, I talked about advisory opinions, and an advisory opinion is confidential. You can waive confidentiality, so I talked about some that had the names. If they don't waive, you'll see the case listed like this, in re public officer. So we had a member of a board. They were a regulatory board, and they said, hey, my employer, remember that's on your magical list of relationships, my employer is part of this subset that we regulate. What do I do when those come up? And so if you look up on our, if you go to ethics.nv.gov, we have an opinions page, and this 23094 case is on there. It is a great one for you if you're on a board or commission, or if you're a DAG watching and you need to advise your board or commission, because this case, this 23094, it goes over those disclosure requirements, and then it walks through different scenarios about when abstention is required. And in that particular case, based on the facts we got, we said, hey, if you're talking about general industry discussions or decisions, you need to disclose, but you can probably participate. If you're changing regulations, that's likely going to be a disclose, and then you can participate because you're not going to change regulations that only affect your employer. But also we noted that if you're changing a regulation and that regulation only applies to your employer, then you're going to need to abstain. And then if there was specific action related to the employer, like they're going to revoke their license to operate, then that clearly required disclosure and abstention. So if you take a look at that case, that In Re Public Officer 23094A is a great case to have handy when you're wondering what you should do. We'll walk through some test cases. So if you're a licensing board member and you have a friend from high school there before the board for a disciplinary action, do you have to disclose and abstain? I'll just give you a couple seconds to answer that for yourself in your head. And then I'll walk you through the analysis. So a friend from high school is probably not enough to be a commitment in a private capacity, unless it's like a friend from high school that you text every day and go on vacation with, and are close to, like a close family member. They're probably not going to qualify as a commitment in a private capacity. So if that's the case, then disclosure is not required under the ethics law. If they do have a commitment in private capacity, then and it's a disciplinary action, it's effective only to them, then you're probably you would need to abstain. Now, sometimes we get a question like, could I disclose anyway? And sure, just because the ethics law doesn't require you to disclose doesn't mean that you can't, for the sake of transparency, for good government, disclose that particular relationship. Where it gets tricky is like if you disclose a relationship and you didn't need to and then you abstain, then you're really, especially if you're like on an elected board, right, you're not participating on a matter where you should, and there's no legal reason for you not to participate. Next example is the director of a commission. Their uncle is regulated by the commission and has to pay the annual fee. The director is proposing to the commission fee changes. So I'll give you a second to think about that one. Uncle is within the third degree of consanguinity, but in this case, the uncle's going to pay the same fee as everyone else, so you would do a disclosure. And in this case, it's the director who's probably not voting, but the director would need to disclose, and then the director could then advocate for the fee change once they've disclosed. The director is not going to vote, but the director remains a public officer in most cases. The last example, a board member is employed by Company A, and Company A is applying to the board for a decision on expanded services, let's say. I'll give you a couple seconds to think about that one. So if the board member is employed by Company A, they have a commitment in a private capacity to their employer. And in this instance, the decision is directly only about Company A. Therefore, there would be disclosure and abstention would be required. And the disclosure would simply be, I am employed by Company A, and this is a matter that will directly affect them. A reasonable person would be influenced by that relationship that I have, and so I'm disclosing that conflict of interest, and I have decided that I'm also required to abstain under the ethics law. Let's talk about some test cases. So In Re Ramos. Ramos was a county manager, and he did not disclose or abstain while processing invoices before his board of county commissioners, invoices that would go to his sister-in-law. So that was a violation each time he failed to disclose and abstain from that process. In Re Green, this was another one that the audit folks had on their list. They had identified issues. They talked about a Nevada Commission on Ethics case. So Green was the secretary-treasurer of the State Board of Homeopathic Medical Examiners. And this one was interesting because he voted, there was an agenda item where they voted to pay him $15,000 salary. we first got the case, we took a look at it, we said, you know, why is a board member voting to pay themselves a bunch of money or participating in a vote, a discussion to pay themselves a bunch of money? That seems like it could be an unwarranted benefit. But also in the formal vote, there's no disclosure or abstention that is in detail. When we reviewed the public meeting, which was somewhat chaotic and hard to follow, so I'll just say, like, if you can make your public meetings as clear as possible when it comes to votes and disclosures and abstaining, that is always helpful, and we'll do the most to protect yourselves. But we took a look at the statutes, and the statutes of the Board of Homeopathic Medical Examiners allowed payments to the Secretary-Treasurer for work they were doing on behalf of the board. And so the payment itself wasn't an unwarranted benefit because there was a statutory provision that allowed it. Similar to like the Tonopah trip, like, okay, there's a reason, there's an allowance for this in policy or law. But what Mr. Green failed to do was he failed to refrain from advocating for himself. So there's a question about whether he voted or not because it was unclear in both the minutes and the video, because it was all on Zoom. But he definitely advocated for himself to get paid, which was a violation of the abstention rules. In re Ancho is an interesting one. It's an advisory one. Again, we're here to provide advisory opinions. And in this case, the Board of County Commissioners was looking at changing the county retiree benefits. Well, this county commissioner was a retiree of the county, and so would have been affected by any change to retiree benefits. In her first meeting, she did not disclose or abstain from the conversation. And then the second time it came up, she thought, oh, I should probably disclose, but I'm not sure if I have to abstain. I think she abstained from that second one. And so then she came to us and said, hey, I think I might have screwed up this first vote. I'm not sure, like, how do I do this in the future? And the advice from the commission was, yep, you screwed up that first vote. We will, if you ask for an advisory opinion, we won't then like go and file a complaint against you because you're asking for help. We said, yeah, you definitely screwed up that first vote. The second vote where you abstained, you actually probably didn't have to abstain because the decisions that you're talking about affect all retirees the same. So you absolutely should make a formal disclosure, but you don't necessarily need to abstain because all retirees are being treated the same. And then a recent one, which we haven't gotten, we don't have a lot in our history, is In re Gibson et al., which was a group of Clark County commissioners who got a gift from Formula One of a 4-day all-access pass to the race, worth about $10,000. And shortly after they had received and used the gift, although they didn't use the full capacity of the gift, but shortly after they received the gift, there was a vote on a financial exchange between F1 and the county. It was actually money from F1 to the county for emergency services, but none of those county commissioners disclosed the gift on the record at the time that they voted on that. And so that was a violation of the law, the fail to disclose the gift. I will take a quick pause because I think this is the one where are there questions about disclosure and abstention before we move to cooling off?
Did they still get to go to the race?
Did they still get to go to the race? So they went to the race. I will say they got a 4-day all-access pass. I think only one commissioner went all 4 days. He was also the head of the Las Vegas Convention Visitors Authority, which was a main sponsor of the race. The others went 1 day to get a kind of a tour of the operations and some ceremonial duties. And so the commission did not make a determination about the appropriateness of the gift, but did say you got a gift and then you failed to disclose that properly. So the disclosure was the focus of that particular.
So were they fined?
They did not receive, no, they did not receive a fine. They were required to go back to their county and they're required to go create an ethics officer for their county and then update their policies on event attendance. And it's also caused the commission, as we're preparing for the next legislative session, to look at our actual, we don't define gift anywhere in the ethics law now. And so a lot of other states have provisions for ceremonial attendance or educational attendance. We're pretty silent on that. And so, yeah, they were not fined, but they did all receive non-willful violations. Any other questions? Vegas, any questions? Disclosure and abstention? This is an area where it would be helpful to get a advisory opinion if you know there's going to be a recurring potential conflict of interest on your board or commission, because then you can get exact guidance on what you're supposed to be doing. Okay, cooling off. When someone departs public service, there are certain people you can't work for, and there are certain things you can't do within 1 year of departing public service. So for 1 year after you depart public service, let's say your term is up as a commissioner, or you're a director and you get fired, or you're a director and you resign to go take another job. For 1 year after you leave public service, you cannot seek or accept employment with a vendor of your agency, or a private company, or someone regulated by regulated by your board or commission. So let me walk through those, because there's lots of kind of qualifications on that. First one is, if it's a vendor for the agency, the contract has to be worth more than $25,000. It has to be awarded within the 12 months before you left, and you had to be in a position to influence the award. So if you're on a board or commission and you're approving your agency contracts, that you clearly meet 3, but you'd want to check those other 2. Is this a contract for over $25,000, and was it awarded within the 12 months before you left? Under the regulated one, there are specific exceptions which apply potentially to this group. So if you are on a board that does licensing, and one of the requirements of you being on the board is that you have a license, then this will not necessarily apply. So I will stick with chiropractors, I guess. So if you're a chiropractor and you're on that board and you have to have a license, and you're on the board as like one of the seats that is required to be a licensed chiropractor, then clearly you can just keep doing what you've been licensed to do under the ethics law, but definitely worth a look before you depart public service. The other thing to note in here is that under this, who you can't go work for, you can ask through the advisory opinion process if, let's say, what you meet these qualifications and the law would prevent you from going there. Before you get employed, you can ask the Ethics Commission for permission to do so. And there's a 3-factor test under the law that says if it's in the best interest of the public, there's no other ethics laws implicated, and it doesn't detract from the ethical, the ethical reputation of your agency, then we can grant relief. And the commission really tries, in cases where it's appropriate to grant that relief, to permit folks to move up beyond public service. Then the other restriction under the cooling off is there are certain things you can't do after you leave, no matter who you work for. And that's simply, you cannot get paid by a private entity or person to counsel or lobby your former agency on an issue that was before them at the time. So if you, let's say we're saying, hearing a disciplinary action in your board or commission, and your term ends, you can't then go get hired by that person who was facing a disciplinary action to help lobby your old agency on that disciplinary action. Same thing with vendors. If you, if your agency or board had like an RFP out and you're accepting applications and your term ends and you can't get paid by one of those potential vendors to help them with their RFP application. Again, the 1 year, it's only a 1 year prohibition. It doesn't matter how you leave public service. If it's termination, resignation, retirement, something else, the restriction still applies. On our website, we have a resources tab. Again, that's ethics.nv.gov. On that resources tab, we actually have I think it's 2-pager on the guide to leaving public service, which helps focus on the different rules and things you should know about. So what can happen if you violate the ethics law? There's no ethics jail. But if we get a complaint about your conduct, and at any stage, really, we determine there's no violation, but there's some issues, we can issue what we call a letter of caution or instruction. A letter of caution says, we took a look at this, it looks like you probably crossed the line, but it's a minor crossing the line, maybe it's your first time ever having some issues. We're going to let you know that if all of these facts that are alleged are true, you you probably violated the ethics law, and here's some educational resources, don't do it again. We keep that on your file. A letter of instruction is somebody maybe complains about you, and we take a look and we say, oh, you didn't violate the law, but you got really close. And so here's some educational materials about disclosure abstention. Here's some guidance on what to do. Feel free to ask us for an advisory opinion. If the commission determines that you violated the law, they have to determine if it's willful or non-willful. I don't like this term because it's really more about severity than willfulness. A non-willful violation, the Ethics Commission can require that you complete ethics training. We can mandate apologies. We can issue an admonishment. If you received a financial benefit, we can require you to pay that back. We recently had a case where a state employee had helped make sure their food truck that was a bar was a vendor at a state party for a collaboration kickoff. Their bar made profit, and so we made them pay back the profit from the party that night, as an example. Under the law, we can actually double that fine if it's severe or if it's appropriate in that case. And then we can also put conditions on future behavior. So when I talked about that Clark County Formula One case, we had those conditions of you're going to institute an ethics officer at your county, and you're going to update some of your policies. We've done that on a number of cases. So those are all things we can do in the non-willful. If it's willful, we can still do all those things, but at that point, the Ethics Commission can issue civil penalties up to $5,000, $10,000, and $25,000, just a flat penalty. That's first, second, and third violation. And then we talked a little bit about the requirement to petition someone for the removal of the public officer. There's also some more severe admonishments. There's a reprimand and a censure, which again is just like formal governmental finger wagging, really, that can be applied in willful violations at certain points. So those are the rules and the scary, like this is what will happen to you if you violate the rules. I'll talk to you about some tips and best practices now and some resources, and then we'll close out, and I'm happy to answer any questions that you may have. So my first tip is to maintain that list of individuals that you have a commitment in a private capacity. Who's on your magical list of relationships? Take a look at it. I don't know, every new year when you change the batteries in your smoke detector, whatever it is, relationships change. But if you have a good awareness about who is on your magical list of relationships, you will be able to identify a potential ethics issue far in advance and call your attorney and figure out what to do. You want to familiarize yourself with your local agency policies. If you're a decision maker in your agency, right, you want to know, do we have policies in place to help protect our employees from ethics violations on conduct that we think would be appropriate? Be proactive in identifying potential conflicts of interest as early as possible. This is for our boards and commissioners. Say, look at your agenda once to understand what the meeting is going to be, and then look at your agenda another time and see if you have anybody on your magical list of relationships that could be affected by those items. We had one county commissioner one time who halfway through an agenda item realized that the person before them, they had a commitment in a private capacity to, and so they'd already gone too far and advocated and were working on the agenda item. That was a perfect example of a letter of caution. Hey, you should be looking at agendas beforehand. When you realized it midway through, you stopped, and so good job doing that. But be looking at agendas for potential conflicts of interest. Know that if you are unsure, it is better to disclose than to not disclose, because that will at least give you the presumption of participation if somebody questions you later. Consult with your legal counsel, and I say this for a couple reasons. One, we have prior opinions on our website, and your legal counsel can, with their skills, research those and maybe find some previous cases that match your fact pattern and can give you really solid legal advice. Also, if you ask your legal counsel for advice and you follow that advice and it turns out your legal counsel was wrong, then the Ethics Commission, we have what's called the safe harbor provision, and the Ethics Commission cannot find that your violation was a willful violation. So it'll be non-willful if you followed the advice of your legal counsel. They gave you advice in good faith. So that's another reason to ask your legal counsel. As the commission, as staff of the commission, we can't provide legal advice outside of an official advisory opinion process. But if you or your legal counsel call us and ask for educational materials, we're happy to point you in the right direction. And then, of course, you can always request an advisory opinion because that will give you the most protection in any particular matter. Some resources. We do have an ethics newsletter, so if you go to ethics.nv.gov, you'll see, I think it's on the right-hand side, there's like 4 public officers. You can subscribe to our newsletter. You can request live, in-person, or virtual ethics training for your commission. We go to meetings on a regular basis or board retreats and do training for those. We have self-paced training online, so if you're like, I don't want to get the whole gang doesn't need to be trained, or maybe you have a new board member that's come on board and you want to get them, so you can go to Nevada Ethics Online on our website and just sign up for self-paced training. And then also we've recently, within the last 2 years, updated our ethics manual, which has chapters on each of these topics. So the old ethics manual was like 50 pages, and it was just one big, gigantic document. Now we have it broken up because we figured that when people have an ethics question, they're not going to want to sit down and just read 40 pages of ethics stuff. They have a specific question, and so we would try to make that as easy as possible to find. You can also follow us on social media. We have an X account and a LinkedIn account. We'll post sometimes articles or updates about cases on both, and so if you have a LinkedIn or an X, feel free to follow us. Just look up Nevada Commission on Ethics. Other than that, I'm going to just toss up this QR code, so if you have feedback, we would love to hear some feedback about the training. I think there's like 5 or 6 questions, and other than that, I will take these last 5 minutes and answer any lingering questions or confessions or whatever. Okay. So the question, if you couldn't hear it, was like, can you summarize the distinction between disclosure and abstention? Disclosure is about being transparent about your conflict of interest. Hey, I have this relationship, I have this interest that could be affected by this decision. It's just saying, this thing is out there. Abstention is saying, I will be so affected, or someone I know will be so affected by this vote, I cannot be impartial in my vote, or a reasonable person would not be impartial in my vote. It's the same standard, right, as the gift. It's not so much about you, it's about a reasonable person, that I will not be participating. So the disclosure is about transparency. Abstention is about saying, I don't think I can be impartial in this vote, and so I'm going to sit it out. And I will say an important thing, especially for boards and commissions, because people get worried like, well, gosh, if 2 people abstain, then we don't have quorum and all hell breaks loose. Under the ethics law, if you have members of your board abstaining for purposes of the ethics law, then your quorum drops by that person. So you're not going to grind all government to a halt. If like everybody abstains, then we got a whole different situation. We got to figure that out. But just don't be afraid to abstain and wreck a quorum, because the quorum number will go down. Any additional questions? Okay, great. I'll hand the baton off to the next person.
Rosalie Boardlove would be our next speaker. Is she here?